Everybody ain't your friend, everybody ain't your partner. I say I got you. Well, just hold it down and keep it solid. And when you're not around, I protect your name, I won't talk about you. Everybody ain't your friend. It's been a long time, honey, but I know, yeah. Store. Everybody ain't your friend, everybody ain't your partner. I say I got you. Well, just hold it down and keep it solid. And when you're not around, I protect your name, I won't talk about you. Everybody ain't your friend.
Hello, everybody. How y'all doing? Welcome back to the channel. It's your girl, Phylly Phyl. All right. As you can hear, I'm still not 100%, but I'm not bedridden, thank God. I'm feeling better, but I'm, my voice, I'm still a little stopped up and stuff. But I said, I can get on in there in the computer room and talk to the people for a little bit. Let me see here. Hold on. Let me, excuse me, y'all. Excuse me. What was I at? I wanted to do, I got my, okay, here I am. Y'all can see me. I don't look too bad. I put on that gold lipstick and that eyeshadow that's so popular, to try to help myself out a little bit. That gold lipstick. Oh, if I have to get off and, then I got my hand sanitizer over here too. I'm staying sanitized. I got everything I need, y'all. I believe. Okay. All right. Who do we have in here? The TV. I couldn't get the freaking TV to work. And I got the game on up there. So I got a lot going on. At 12 o'clock. Tamika, how you doing, Tamika? Good morning. Hello, Rosalind. How are you doing? Hey, Kizzy. How you doing, Kizzy? I'm trying to get 100. I'm trying to get that, Kizzy. Trying to make it. I got to make it. Hello, Alice. How you doing? Okay, Boss Man is in the building. Raven Simone? No, how you doing, Raven Bellamy? Okay, how you all doing on this Sunday? I hope none of you are sick. Okay. Good afternoon, PP. How you doing? Hello, Books. How you doing, sis? Hello, Terry. Support and share EWPP is my world. Yes, that's my newest channel. Okay, it's moving right along. We go over there when we just want to, talk about irrelevant stuff. Hello, Leslie. How are you doing? Lakeisha, this here is the channel right here. This is the people's channel. It's the cold case channel, where we bring cold cases back to life. Okay, well, we fight for the victims and their rights and their families, okay? This is what we do over here. All right. Hello, Power Dynamics. How are you doing? Welcome. Everybody, what's going on? Make sure y'all hit the like button as you come in so it can get this video on out there into the algorithm. Okay, now y'all saw the title. Judge denies Tim's request. And Tim's attorney said, we want an acquittal there. Just clear out, cancel out the doggone guilty pleas, the guilty charges that were found. Okay. Hey, No Filter, how you doing? Tim, here's the judge. Look, the judge denied it. We're gonna read it. Y'all know I got the documents. I got the documents. It may not sound as good as me, reading it to you today as it has in the past. But I got the documents, all right? Maybe if I talk like this, I'll sound a little better. Oh, goodness. Hey, Miss Vicky, how are you doing, Miss Vicky? No Filter say, Kizzy. Did y'all hit the like button, everybody? Did everybody hit the like button? Okay. Come on into this LLC business over here, okay? This LLC business, limited liability over here, okay? Hello, Valerie, how are you doing? Rosalind, Hope you feel better soon. I'm getting there, Rosalind. Whew, much better than I was 2 days ago. But I'm still not 100, and it's the holidays. Be of good cheer. Be of good health. Sharon, I'm glad you're feeling. Yes, I am definitely feeling better than I was. Thank God for that. Yes, honey, God is definitely on my side. Hello, Celia. Hello, everyone. Hello, Phylly. How are you doing? Shout out to all the members in the building. Shout out to all my members. Let me say this to my members real quick and to any new potential members.
I want to thank you. I want to thank you.
I want to thank you. Thank you for being a friend. Oh, goodness. No nonsense, Stucky. Happy holidays and all in attendance. Happy holidays to you, too. Yes. Happy holidays to you. Laverne, how you doing, Laverne? Another member? Thank you. You look good. I do. Well, child, it took all I had to get this way. That old gold lipstick helping out a little bit. What about that eyeshadow stuff? Okay, it's doing anything. Oh, goodness gracious. I got the ponytail. I got it slicked down and looking pretty good, I think. Okay. See, don't make me act silly, y'all. Don't make me act silly. Hey, PP, have a blessed day. You too, Miss B. Belton. You too. You too, Laura. Good afternoon, Phylly. Feel better. Yes, thank you so much. Hey, Tim is done. Do I have any St. Louis? Do I have the Lou in the building anywhere? Is St. Louis in the building? Where's my St. Louis people? I know Miss Mary might be busy, but she says she always watching me. Zaza, hello. I hope everybody have a great day. Laugh at your haters and blow them a kiss. Okay, blow them a kiss. We're going to talk about Tim and him. Tim, does Tim have any haters? The judge might be his hater. He might think the judge is his hater. Good, PP, and stay blessed. Hello, Taylor Made is in the building. How you doing, Taylor Made? What's going on? Taylor doing her thing over there on her channel. You better come through with them. Moderators have lives too, and so does us content creators. Whoo-wee. Our lives matter, however you put that. I'm so happy the judge denied this. I know. Okay, Bree, hello. Come on in, y'all. So we're going to get started here in a minute. We're about to get to the content. But before we get started on that, let me tell y'all, I had a call this morning. We talked about 2 hours. Another mother. I had mentioned her before. It's a Detroit. It's a Detroit connection. Yes. And I may come back and do that story later, start the story, because she will be coming on and doing an interview. She will be calling in, or however we do it, or live. I mean, I don't know how we're going to do it, but she definitely wants to speak. But her son lost his life. He was 27 years old. He had only been 27 2 days. He lost his life November the 4th of 2020. He's from Detroit. He moved to Arizona when he was 14 to stay with his grandmother, his father's mother. And he would be back and forth. He'd come home to Detroit, in the summer and stuff, or whatever, holidays. But he's lost his life, and his mom is definitely fighting to get justice for her son. Another mother fighting for justice. Justice. So I will be telling you all more about that, but we talked for about 2 hours. There is a trial starting in Arizona, January the 23rd. So there has been some arrests, but there's just still more going on. It's still an ongoing case. So it's not really a cold case. It's an ongoing warm case where we've got to make sure justice is definitely completed for this mother. Okay, for her young son, 27, never had a chance to marry, never had a chance to have children, another young man not being able to live to their full potential. Okay, and he was hanging around family members. I'll just put it like that. But anywho, we will be getting into that. So you guys, please stay tuned. We do have another case that we're adding that we'll be talking about in this section. Do I know anyone in Detroit? I do. Unspoken Purpose. I don't know her, but she's a content creator, okay, and a supporter, and I support her. So that's the only person I know in Detroit, okay, that I can think of right away that's of any relevance to my life, okay. And now this mother, okay, who lost her son. All right, I said what I said. So let's carry on. PP Brit Effects. Yes, I do try to do that. Hold on, let me get myself together. I'll be right back. Hold on a minute, y'all. Y'all know I told y'all this might happen. Okay, I'm back, y'all. I'm back. Ugh. Woo, child. It's just a mess around here. All right. Somebody says, good morning, PP. My name is, I've been following you since the Tim Norman case first started. When is your court date here in the Lou? I am and will support you here. Let me say my family and I are going to support you. Please keep me posted so I can be there with everyone else, support and cheering with you. Thanks, with love. Okay, it's February the 6th. I will text you. I will get back to her. Thank you so much if you're watching. Need all the support I can get, all the cheers I can get. Okay. Okay, y'all. So we're going to go ahead and get into this. I said he was going to try it. Yes, we're going to get into this. Trevor not in there out here, is he? Y'all seen Trevor? Much love. Hello, Raven. Yeah. Power Dynamics. Terry Mendez. Just sentenced him. Well, he does have rights. As you know, even the guilty, you can be guilty and it can come out your mouth. You still got rights. Yes, child. Isn't this something? The guilty has the criminals have rights too. Yes, they do. All right. They do have their rights. Hello, Miss Lorraine, my friend. Miss Lorraine in here. Did I miss her? Hello, Miss Lorraine. Top of the West Coast, morning to you, Miss P. Hello, Eddie. How are you doing? Top of the morning to you. Munda Tucker, Queen Tux Creations. Hello, how are you doing? That's my friend, Miss Lorraine. What's going on? Yeah, that trial is going to be starting in Arizona. I got a case I'm covering out, and I heard it never rains in Arizona. Is that true? Oh, that's what Calvin said. Okay, did Tim get his sentence yet? No, honey. Tim's still fighting. Tim don't even think he done been found guilty yet. Tim don't even think he done went to trial yet. Tim don't even think anyone has lost their life, according to Tim. If you look at the way he acted. Oh, hello, my babies. Hello, Faith Samari. How are you doing? Did I say that right? You got to be. I'm doing my best. I bet I won't yield. I bet I won't yield. Hey, sweet sugar, your family, phenomenal. I love that. The men in your family like a buffet. Oh, my goodness. Thank you. You must have saw my little collaboration of clips that I put together. I have so many more. I couldn't find. I got to download them. Other clips that people have made. Family, my close family and friends that I truly do love, and they truly do love me. Yes. PP, make you some hot tea with lemon. Okay, I've done that. I've done it all. I've done it, y'all. I done did it. I got lemons up in there. I got honey. I got E&J. I got everything. I'm trying everything. I want to get better. I got places to be. I got to get myself together because I got somewhere to go. I do. I'm trying. I need to go back to work. I'm trying. Oh, goodness. Okay. All right. Hello, Jason. Is that the Jason? I wonder if that's the Jason from Texas. How you doing? He called me a couple of weeks ago. I hadn't heard back from him. St. Louis in here. Okay, Miss B. Belton, how you doing? What's up in the Lou? Okay. My St. Louis connects. I love St. Louis. I do. I love St. Louis. Hey, First Family Lady Ma. Hello there, Keisha. You remember Keisha called in and told us not her story, her very sad story, but, you know, about her loving brother and how everybody ain't your friend and everybody ain't your partner. Okay. Boy, don't we remember that. Everybody getting a text but the brother. Thank you for sharing that with us, Keisha. I'll never forget that story. Having a blessed, yes, you be blessed as well. Okay, we're going to go ahead and get started. Oh, wait a minute. God dog it. Hello, Queen Black. How are you doing? Thank you, Miss Vicky. Welcome to the Eat with Phylly Talk Show and more. Absolutely. At first, they said they were going to send him on December 15th. Now, that was moved to sometime in January, but I've got to double check on that, child. They changing up everything. Okay, let's go ahead and get started with this one right here first. So, Defendant Norman, now this was on the 13th. I don't think we read this. This is another one. Okay. Defendant Norman's motion for leave to file reply instiner in support of emergency motion to extend time to file post-trial motion. Defendant Tim, by through his attorneys or whatever, states as follows. Defendant's post-trial motions are currently due to be filed tomorrow. Now, so this was filed on the 13th. That was meaning they would have been due to be filed on the 14th. 14th is on what date? Let me look at my calendar. That would have been Wednesday. So this was filed last Tuesday. The government has filed a response without leave of this court to defendant's motion arguing inter alia that they oppose the extension of time now, but had not in previous times. So this is where they're saying that the government has filed a response. Remember, the government said, wait a minute, we're not agreeing with that. We agreed with the other ones, but we didn't say we was automatically agreeing with this one. All right, remember that? Guys, wait a minute. I told y'all we might have to, hold on, guys. Bear with me, good people. All right. The government specifically stated they did not oppose the defendant's prior request when it was sought on November 30th, when the motion was filed stating that the defendant requested an extension to January 23rd. The government also did not file any objections to the date of the extension beginning January 23rd. The court even refers to the government's position of not objecting to the defendant's motion in the court's order, stating that the government does not oppose defendant's request for additional time. The government did not thereafter file any objection or motion seeking to clarify the record. The government now wants to say they oppose any extension of time, stating verbatim in an email to the undersigned counsel on 12/13 at 10:12 a.m. Oh, they got the receipts. Based on the exhibits you filed, it is unknown when a finalized transcript will be ready, and this could continue in, how do you pronounce that? Perpetuity? I probably didn't get it right. Hey, count it to my illness right now, okay? Defendant is seeking this extension to January the 6th, 2023, which is 2 weeks sooner than the prior request of January 23rd, of which the government had no objections. So they're saying the government had previously given them up until January 23rd, so why won't they give them until the 6th? Okay, that's what it looks like. Then it says, number 7, the government's position is inconsistent and only serves to take a tactical advantage over defendant Norman. Imagine defendant Norman saying that someone is trying to take advantage of him and bully him. The government's objection is also unreasonable, and their concern is meritless, given that the pre-sentencing report has not been completed and that the defendant's objections to the PSR is not even due until February 16th. That's the post-sentencing report, okay? Where they check their history and all of that good stuff. Let me see what y'all are saying over here. What y'all saying over here. Okay. Yeah, Tim's attorney is definitely, when you have an attorney, when you pay for an attorney, that attorney is supposed to stand up, speak. You may not even have to say a word. That's what you're paying your attorney for, okay? That's what the attorney is for. They're the experts, not you. Only a fool would defend themselves, okay? I digress. All right, let's carry on over here. Number 9, engine. The other interested party, i.e. the victim's family, in this case, are not prejudiced in any way by having this extension to January the 26th, as the sentencing is not until March the 2nd, 2023. So the sentencing is no longer in December. Remember, it was moved to March the 2nd. The only party that will be severely and irreparably prejudiced by this motion being denied is Mr. Norman. Well, you don't say. Wherefore, defendant Mr. Norman, by and through his undersigned counsel, respectfully requests the entry of an order granting him additional time up to and including January the 6th, by which to file his post-trial motions and for such other and further relief as is appropriate under the circumstances. Okay. All right. There we go. So, hold on. Let me come back over here. As you can see, they're asking, they wanted to get to January the 6th. They're still wanting additional time. Shout out to the 200 people in the chat. I truly do appreciate it. Make sure everyone hits the like to get us back in that algorithm. We know how to do that. We're going to show them how you do it over here. Okay, let me come on back over here. So now we're going to move on to the next one. And again, if you're just coming in, I'm a little under the weather. My voice isn't 100. I'm a little stopped up. So if I got to leave the camera for a minute and take care of some things, just know I'll be back. Just know I'm still here working for you and the family and the victims, okay? This is the People's Channel, where we bring cold cases back to life, all right? I hate when I say that, so I love to say it. Teletubby hips, you're gonna get like. Oh my goodness. All right, let me try to pull up this other let me pull this other one up. I'll be back. Okay, I'm back. That didn't take long. Here we go. So, December the 13th. Okay, here's an order. Here's the order from the judge. Before the court is defendant's emergency motion for an extension of time to file his post-trial motions currently due on December the 14th. Contrary to defendant's representation that the government does not oppose his... Now, see, they're saying it's due December 14th. What they just tried to say is that it wasn't really due until January 23rd. Somebody lying is all I'm saying. Contrary to defendant's representation that the government does not oppose his request for additional time, the government responds that while it expressed no objection to defendant's previous motions for extension of time, defense counsel never consulted with it regarding the filing of the instant motion. The government asserts there is no basis under Federal Rules of Criminal Procedure 33 or 45 that warrants further delay of the filing of post-trial motions in this case. The court agrees and finds the reasons given by defendant do not constitute a basis for an extension of time under the Federal Rules of Criminal Procedure. Counsel appears to misunderstand the role of post-trial motions. Let me read that again. This is the judge talking to Mike Leonard. Counsel appears to misunderstand the role of post-trial motions in seeking a full transcript of the trial proceedings. To date, counsel has received over 600 pages of the trial transcript, and a full transcript or portions thereof will be available if an appeal is filed. The full trial transcript is not necessary for purposes of filing post-trial motions. They were trying to say we need the full transcript in order to file our post-trial motions. No, you don't. There is no basis under the federal rules for granting this extension. Accordingly, it is hereby ordered the defendant's emergency motion for extension of time to file his post-trial motions is in all caps and bold denied. Dated this 13th day of December the 2022. Y'all see that? It's denied. Judge Ross not playing, okay? He not playing. All right, so as we can see, it was denied. And we have some more documents to go over. Let me get it together here. I'm back. So here's the next document that was filed on, when was this document filed? Hold on, it's so many documents around here, honey. We got a lot to cover. December the 14th. All right. Defendant Norman's motion memorandum in support of his Rule 33 motion for a new trial. Defendant James Timothy Norman, by and through his undersigned attorneys. All right. As we know how all that goes, you know, we've read that 1,000 times. They're asking for an entry in order vacating, the jury verdict and granting him a new trial, and states as follows as his memorandum in support. Here's his reason he feels he should get a new trial, okay? Maybe part of the reasons, but here's Tim's attorney asking for Tim to get a new trial. Pursuant to Rule 33 of the Federal Rules of Criminal Procedure, a trial court may vacate any judgment and grant a new trial if the interest of justice so requires. Wow. Here, as set forth below, the interests of justice clearly mandate vacating the jury's verdict and ordering a new trial in light of the numerous and substantial errors that arose in connection with the trial of this action, which had a significant impact upon the trial and substantially prejudiced Mr. Norman and denied him a fair trial. So here's their arguments. Here you go. The trial court erred, meaning they erred, they messed up in denying defendant's motion to suppress arising out of his arrest and the seizure of his cell phone. They say that they messed up when they took his cell phone and let it become part of the evidence, and thus erred in allowing the admission of that seized evidence at trial. So all those text messages, pictures, the surveillance that was shown to be being done over Andre with people following him, they're saying all of that should not have been, all of that evidence that helped prove Tim's guilt should never have happened because they erred, okay? Whatever. Pursuant to rules, y'all can read those numbers if you want. That motion sought to suppress all evidence seized in connection with the execution of an arrest warrant on or about August 18, 2020. Mr. Norman incorporates by reference, as though fully set forth herein, the argument and case law support that he previously provided this court in support of that motion. And it tells you to go to docket number 183. We've already went over that docket. I don't remember which one it was, but we went over every docket they've posted, okay? That's available to the public. In addition, Mr. Norman incorporates by reference, as though fully set forth herein, the testimony from the evidentiary hearing that was held in regard to that motion. However, in sum, and to refresh the court's recollection, so let's refresh the court's recollection. Agents conducted an unlawful warrantless search within Mr. Norman's residence without Mr. Norman's consent and without probable cause, and seized his cellular telephone. There was no basis for that search. The agents did not have probable cause for it, and it violated Mr. Norman's Fourth Amendment rights. Help me, somebody. I hope that's not true. After an evidentiary hearing, that motion was denied. It must not be true because it was denied. Accordingly, as the court well knows, the government was then able to base its case in chief in significant part on the contents of that illegally seized phone. So they're letting you know that Tim's conviction, him being convicted, relied a lot upon that cell phone. I don't know why he didn't delete. Well, I guess they could have pulled it up, but I don't know why he kept all that evidence in that phone. Goes on, there can be no dispute that such evidence substantially prejudiced Mr. Norman and was the foundation for the jury's guilty verdict. On that basis alone, this court should order that Mr. Norman is entitled to a new trial. What are you all thinking about that? Let me come over here and see what y'all thinking. Oh, the happy couple with the honeymoon in the segregation area. Child boo, they need to stop the foolishness, okay? I'm so glad you're reading the documents again. I miss it. Yes, honey. As long as we got documents, I'm going to read it. Judge Ross will deny Tim's motion for a new trial. He probably will. He may have already denied it. I just ain't gotten to it yet. You know I'm behind. Didn't already fight about the cell phone? Yes, honey, but that's what they're basing their appeal on, Miss Vicky. Mm-hmm. Judge Ross sick of she hips. He claiming unlawful search and seizure, Fourth Amendment. That's what he's claiming. Yes, yes, yes. Yes, indeed. Okay, let's get back to it then, child. Let's get back to it. B, the trial court erred in denying defendant's motion in limine. Remember all those motions in limines we had to go through? Mr. Norman moved in limine to bar Andre Montgomery's foundationless, wholly irrelevant, non-probative, and highly prejudicial statements regarding that Mr. Norman, see docket number 287, I'll pull that docket. Mr. Norman incorporates by reference as though fully set forth herein that motion, including the case law cited, as well as the arguments that his counsel made in support of that motion at the final pretrial conference. Let me read that again. Mr. Norman moved in limine to bar Andre Montgomery's foundationless, wholly irrelevant, non-probative, and highly prejudicial statements regarding Mr. Norman. He was scared of you, Tim. Come on down here. However, in sum, and to refresh the court's recollection, Mr. Norman sought to bar the government's introduction of Mr. Norman's highly inflammatory and prejudicial statements, suggesting that Mr. Norman was out to get him, or to use locals word, unalive him. The court nonetheless allowed those statements to be introduced in violation of Rules 401, 402, and 403 of the Federal Rules of Evidence. I don't think that judge is that dumb to allow stuff that just should not have been. I just don't believe it. But that's what your good attorney is supposed to do. His attorney is doing what he's supposed to do. He's fighting for him. Okay, doesn't mean he's going to win. Okay, people can fight all they want. Don't mean they'll ever win. They can fight till they die. Doesn't mean they're going to win. Okay, when you're wrong, you're wrong. All right. Rules 403 of the Federal Rules of Evidence, as well as Mr. Norman's Sixth Amendment rights. Didn't I tell y'all everybody got rights, even the criminalistic people? This error was particularly prejudiced because of Mr. Norman's counsel's inability to confront and cross-examine Mr. Montgomery regarding those statements. Where if Mr. Tim Norman had not had Terica Ellis to lure him outside and then have Travell Loco Hill waiting to take him out, we wouldn't be here. It's all your client's fault. Okay. Mr. Montgomery, regarding those statements, there is no doubt that the introduction of those statements was highly prejudicial to Mr. Norman as intended by the government because they provided the much lacking alleged motive for Mr. Norman's actions. This evidence was allowed despite the fact that Mr. Montgomery himself had a strong motive to lie about Mr. Norman's alleged intentions to explain his intended absence from St. Louis and to cover up and make excuses for the fact that he was the one who had burglarized. Oh, I don't believe that. It says, then goes on, Mr. Norman's counsel, the Earl was exacerbated. How y'all pronounce that? Exacerbated from this court when it repeatedly barred Mr. Norman's counsel from introducing relevant evidence directly bearing upon Mr. Montgomery's actions and motives, which clearly were the reason for Mr. Montgomery's intended absence from St. Louis, as opposed to any claim threat that Mr. Norman purportedly posed to him. He was afraid of him. For those additional reasons, the court should grant Mr. Norman a new trial. Mr. Norman also moved in limine to bar co-defendant Hill's foundationless, highly highly prejudicial and irrelevant impressions regarding Mr. Norman's alleged intentions with respect to, and then they put that one, you see that one over there by him? The one is the court has denied Mr. Norman a full and meaningful opportunity to provide this court with all of the arguments and recorded citations in support of his positions herein. In light of its recent rulings, which forecloses Mr. Norman from obtaining all of the complete and relevant trial transcripts, even though Mr. Norman's sentencing is not until March 2023. Mr. Norman is in custody, and no party would be prejudiced by Mr. Norman being provided with additional time to file his post-trial motions after first obtaining those transcripts. That ruling also prejudices Mr. Norman's counsel in his ability to fully raise, by way of this motion, all of the legal errors that additionally support the granting of a new trial to Mr. Norman. Indeed, without all of the transcripts, it is impossible to completely raise and cite to those additional errors of law. Okay, so we're going to go down here. With respect to Andre Montgomery docket 288, Mr. Norman incorporates by reference as though fully set forth herein all of the arguments and case law that he previously provided this court in support of that motion, in addition to the arguments that his counsel advanced in support of them at the final pretrial conference. However, in sum, and to refresh the court's recollection, Hill was allowed to testify at trial regarding what he believed Mr. Norman wanted him to do with respect to Mr. Montgomery. That ruling was error and violates Rule 4.1, 4.2, and 4.3. So they're saying Travail should not have been able to testify and say, what he thought Tim wanted him to do. Again, there can be no question that Mr. Norman impermissibly suffered substantial prejudice based upon Hill's improperly allowed trial testimony regarding Mr. Norman. Indeed, Hill was the only witness. Where is it at? Indeed, Hill was the only witness who was able to provide trial testimony that may have even suggested that Mr. Norman had any improper motive towards Mr. Montgomery. Accordingly, the jury clearly relied upon Hill's testimony as a substantial basis for its verdict. For that reason, the court should grant Mr. Norman a new trial. My. Mr. Norman additionally moved in limine for the entry of an order barring the government from introducing at trial or otherwise referencing any attorney-client communications between Mr. Norman and his prior Texas-based civil law counsel, docket number 291. Mr. Norman incorporates by reference as though fully set forth herein that motion and the case law cited therein. In addition, Mr. Norman incorporates by reference as though fully set forth herein the arguments that the counsel made regarding that issue during the final pretrial conference and during the trial as reflected within the transcripts. However, in sum, and to refresh this court's recollection, the government was improperly allowed by this court to introduce written communication, text, emails. So they're saying that the government was improperly allowed to enter that evidence, the text emails between Mr. Norman and his then civil attorney that he had regarding his retention of her to pursue, including by way of a declaratory judgment action, the proceeds of one of the insurance policies. Remember, Tim was talking to an attorney about getting the money, getting that $450,000. There was no basis whatsoever for this court to conclude that the crime fraud exception applied and allowed the production of those documents to the government in the first instance, let alone their introduction at trial. Those were protected attorney-client communications which were not in furtherance of any crime or fraud whatsoever. Thus, Magistrate Baker clearly erred in the first interest by allowing the production to and use by the government of those obviously attorney-client protected documents. Boy, his attorney is fighting hard for this new trial, guys. Let me see what y'all saying over here. Okay. Boy. These are the reasons Tim's attorney is laying out he should be given a new trial. This is what we're reading right now if you're just joining us. This is the information Tim's attorney is using, saying that he should have a new trial, okay? Justice for Carlita, absolutely justice for Carlita. You better know it. Hey, how you doing? You okay?
Straight on the bed myself.
Huh?
Damn bathroom. That bitch got 3 rooms for a bathroom. A sink in this room, the toilet and the shower in this room, and another sink in this room. I thought it was one damn room.
You couldn't renegotiate?
Oh my God.
I hate that for. Okay, let me put this door back. Well, maybe you can renegotiate one, babe. Okay, y'all. Sorry, Tommy had entered the room. Okay, justice for Andre. Okay, thanks. Yes, Tim trying to get a new trial, y'all. He better save some of that money he's paying for his books. I don't know. You know, maybe Leonard now is doing it, you know, pro bono. Maybe he just wants to prove to the people, show how good he is. Sometimes attorneys will do that. Okay, you just never know. His lawyer is working hard for that money. Yeah, he probably is getting paid. I mean, I don't know who's paying or where the money is coming from. So I'm not going to speculate, but he could be. Hey, Trevor, what's up? Trevor, Baltimore in the loop. Trevor, Tim trying to get a new trial. Trevor, I'm reading the things that his attorney has documented on the reasons that, the basis that he should be given this new trial. Shout out to the Lou once again. Okay, let me get back to reading this because we have some more pages to go. Subsequently, this court compounded that error by allowing the government to rely upon those communications as one of the linchpins of its case at trial. There is no doubt that the jury relied upon those very communications as the basis for its verdict, particularly in light of the emphasis put on that evidence by the government and as further evidence by the jury's deliberation questions regarding those communications. For those reasons, this court should grant Mr. Norman a new trial. Oh, I want some cabbage today, y'all. I hope I can taste it. Mr. Norman further moved in limine for the entry of an order barring the government from calling Bastain Fraud as an expert witness at trial. Mr. Norman moved in limine for an entry of an order. Remember, he didn't want Mr. Fraud to testify. Mr. Norman incorporates by reference as though fully set forth herein the arguments and case law that he provided in support of that motion, as well as the arguments made regarding that issue as reflected in the transcripts from the final pretrial conference at the trial. However, in sum, and to refresh this court's recollection, they're going to refresh the court's recollection again. There we go. The government provided 2 entirely belated and wholly insufficient disclosures of Fraud's opinions in violation of federal rules, including Rule 16 of the Federal Rules of Criminal Procedure and Rule 702 of the Federal Rules of Evidence. I want to read everything because I want to know exactly what they saying was done wrong, okay? And I believe you all need to hear it as well. So it may take me a minute to get through it because, you know, I'm moving a little slower, but we're going to get through it. Nonetheless, this court still allowed the government to rely upon those disclosures and to call Fraud as a witness at trial. Moreover, this court put Mr. Norman and his counsel in a position where it was impossible to obtain an expert to rebut Fraud's opinions, much less obtain all of his prior testimony in other matters of the same subject matters. Thus, hold on. Thus, Mr. Norman was also denied his Sixth Amendment. Look up the Sixth Amendment if you're not sure exactly what it states. Rights with respect to his counsel's ability to fully and meaningfully cross-examine Freud at trial, including for purposes of impeaching him with prior testimony. They was going to impeach Freud. They was going to impeach him. Okay. All of this was too clear error. All of this was clear. Wait a minute. All of this too was clear error and resulted in substantial prejudice to Mr. Norman. In fact, the government emphasized and relied upon Freud's extensive cell phone tower testimony. This was the man that had all of the ping information. You know, your phone pinged here, your phone pinged there. Okay. They knew where Tim was when Tim didn't know where he was. Okay. As foundations for its case. And there can be no doubt that the jury relied upon it as a basis for its verdict. This was yet another example where the government's misconduct and violation of the rule was allowed. They said a government misconduct. Oh, it's a lot of misconduct going along virtually around here. Okay. For all those reasons, this court should grant Mr. Norman a new trial. Ooh-wee. Boy, if I had an attorney like this here. Okay. C. The trial court erred in denying defendants' motions to continue trial and in holding that the government had met its obligation under Brady-Giglio and the Jinx Act. Remember, we went over the Jinx Act and all of that. I can't remember exactly what it stated, but I read it to you guys. Mr. Norman filed motions to continue trial, which were all denied by this court without any legitimate, compelling basis and to the substantial prejudice of Mr. Norman and his counsel. There simply was no reason that the trial could not be continued, and it should have been continued based upon the government's intentional acts in withholding crucial discovery materials. Remember, they didn't want the trial to start at the time it was scheduled to start, but the judge went ahead and let it start. So hey, and now they're coming back saying all of this here. Yes, Julie said, welcome in everybody. Okay, come on, let's get on up to 300 people. Share us out, hit the like button. Let's get us up to 300 in the chat. Let's show them that we still over here fighting. Okay. Still ain't nothing changed but the day of the month and Phylly feel voice because she a little sick right now. All right. Hell no to the no. Okay. You're doing a great job, PP. Thank you, Power Dynamics. Okay. Let me get back to it. Mr. Norman incorporates by reference, as though fully set forth herein, the arguments that he provided in support of those motions, as well as the arguments made regarding those issues as reflected in the transcripts from the hearings held to address those issues. However, in sum, and to refresh this court's recollection, this court forced Mr. Norman and his counsel to proceed to trial. Look at that, y'all. It says, however, in sum, and to refresh this court's recollection, this court forced Mr. Norman and his counsel to proceed to trial, even though the government produced on the very eve of trial, and for the first time, essentially all of the witnesses' statements, more than 50, and witness files, 42 or more, which it intentionally and tactically set on for months and years. Woo-wee. My. Those also included lengthy audio video statements. They didn't want Tim to know because Tim. Okay. In other words, Mr. Norman and his counsel were provided with essentially all of the meaningful evidence that provided the basis for the government's entire case within 2 weeks or so of the trial. in violation of Mr. Norman's due process and Sixth Amendment rights. Mock trial participants received greater ability to prepare for trial than that which was provided to Mr. Norman and his trial in connection with the present case. Okay, Leonard, I hear you. Mr. Leonard says, mock trial participants received greater ability to prepare for trial than what which was provided to Mr. Norman and his trial in connection with the present case. Furthermore, as orally argued extensively before the court, the government repeatedly violated its obligation under Brady Giglio and the Jinx Act by way of its intentionally and calculated failures to produce those materials until the very eve of trial. Justice for Dre. We got to get full justice for Dre. For all these reasons, the court should grant Mr. Norman a new trial. Let's move on to D. They have another reason. Woo! It's 16 pages, y'all. My goodness. Hold on. The trial court erred in denying defendant's motion to dismiss the indictment against defendant Norman, barring defendant Travell Hill from testifying at trial, and denying Mr. Norman the ability to retain an expert with respect to Hill's extensive drug use. Oh, they bringing the drug use back into it, y'all. They are bringing the drug use back into this. They been off in jail. My. Okay, here we go. Let's get back to this. Mr. Norman moved prior to trial to dismiss the indictment to bar the government from calling Travell Hill as a witness at trial, for a continuance of the trial to allow defendant to locate, retain, and disclose an expert witness regarding the government's intentional and belated disclosure of Hill's extensive drug use. You know what? Whatever. Extensive drug use on the date of the occurrence, prior to date of the occurrence, and subsequent to the date of the occurrence. So many occurrences here. These motions were also premised upon the fact that the government intentionally failed to disclose that Hill had been given consideration. Now remember this, consideration for his cooperation, including the dropping non-pursuit of federal drug charges against him. Hold on. Had been given against him. Mr. Norman also requested an immediate evidentiary hearing where the government's representatives, as well as Hill, could be examined under oath with respect to these highly material issues. Y'all remember that? I remember that. I do remember that. Come on, we need to get more likes in here. We got 200 some people. We need 200 likes. We need 200 likes, okay? Mr. Norman incorporates by reference, as though fully set forth herein, the argument that he provided in support of those motions, as well as the arguments made regarding those issues as reflected in the transcripts from the hearings held to address those issues. However, in sum, and to refresh the court's recollection, the government waited until the eve of trial to disclose the fact that one of the most significant witnesses in the case, Hill, aka Loco, had been using drugs extensively on the date that he murked Mr. Montgomery. The government also had intentionally failed to disclose that Hill had an extensive history with methamphetamine, I believe. The government further intentionally failed to disclose the consideration that it provided to Hill in exchange for his cooperation. In addition, the government allowed Hill to falsely claim to the grand jury that he had not received any benefit in exchange for his cooperation and testimony. Even though the government had known about those facts for some 17 months or more, it intentionally failed to disclose them in violation of its obligations under Brady-Giglio, or Giglio. You pronounce it the way you want. Nonetheless, the court denied all of Mr. Norman's motions arising out of the government's misconduct and failed to provide him with any of the relief that he sought. For those reasons, this court should grant Mr. Norman a new trial. All right, here's another one. E. The trial court erred by denying Mr. Norman's motion to compel the government to timely produce Jinx materials. Here's another reason they're laying out a reason that he should have a new trial. He has a lot of reasons. Goodness gracious. Mr. Norman filed motions seeking the government to be compelled to produce Jinx material, which it possessed for months and years prior to trial, in a timely fashion, as to allow Mr. Norman and his counsel the ability to fully and meaningfully prepare for trial and to conduct its own investigations as to those witnesses. Maybe they were given to his previous attorneys. He had so many attorneys. The court denied those motions, resulting in substantial prejudice to Mr. Norman, denying him due process and denying him his rights under the Sixth Amendment. Mr. Norman incorporates by reference, as though fully set forth herein, the written arguments that he provided in support of those motions, as well as the arguments made regarding those issues as reflected in the transcripts from the hearings held to address those issues. However, in sum and as referenced above, the government only produced Jinx material on the very eve of trial. I believe that part, something was produced right before trial and they were in an uproar. As a result, Mr. Norman and his counsel received virtually, you know, a lot of things can happen virtually. Just remember that. His counsel received virtually the entire government production of any relevance and value within 2 weeks or so of the trial, despite the fact that the government had been sitting on and intentionally withholding those materials for years or months. The resulting substantial prejudice to Mr. Norman and his counsel was obvious, i.e., trial preparation on the fly with virtually no time to meaningfully investigate and prepare for trial. For those reasons, this court should grant Mr. Norman a new trial. Oh, then there's F. How many alphabets do we have? All right, what are y'all saying over here? Welcome to the Faith Show is in here. Welcome, everybody. Please hit the like button. Shout out to all the content creators that are in here. I do appreciate everyone's support. Okay. All right. What does this say? When the DA came into the courtroom, he left the door, swings towards Mr. Norman, mistrial. Well, you know what? We're going to see. Boy, only door that will swing is his jail cell. Oh, my goodness. Hold on, guys. started a poll, so you all take the poll, please. All right, let's continue. The trial court erred in denying Mr. Norman's motion to compel Yogman to appear at trial, to grant alternative service with respect to his appearance at trial, and to compel him to testify at trial. Okay. This is Yogman. You know, we have Ja, who's a friend of the show, who's Yogman's good friend. So Tim is saying that they should have made Yogman testify, and for that reason of him not testifying, he should be given a new trial. Let's see what they say here. Mr. Norman's motions with respect to Yogman were fully briefed and were argued orally. Mr. Norman incorporates by reference, as though fully set forth herein, those written submissions as well as those oral arguments, which are contained in the trial transcripts to which Mr. Norman and his counsel do not yet have access. In short, this court erred in refusing to compel Yogman to appear at trial, even though he was under this court's supervision and was evading service. Oh, I can tell you something about evading service. Oh, my. Moreover, after Yogman, through counsel, made it clear to this court that he was not going to appear at trial in any event based upon his assertions of his alleged Fifth Amendment right not to testify, this court again erred. He should have been called in to at least just say, I plead the Fifth. I mean, I don't know. As evidenced by the materials and arguments previously submitted to this court, Yogman clearly and intentionally waived his right to assert his Fifth Amendment rights after providing audio tape statements to the government prior. See, I didn't know that. Hold on a second. After providing audio tape statements to the government prior to trial with the assistance of counsel. In addition, Yogman was not in jeopardy. Yogman was scared. He didn't even want to see Tim Child. Thus, the court's ruling that Yogman was entitled to invoke his Fifth Amendment's right and had not waived them, and that he was not in jeopardy was in error. I always thought if you were gonna plead the Fifth, and see, pleading the Fifth, Yogman was guilty of something. Let me come over here for a second. Yogman was guilty of something. He had a reason to plead the Fifth, okay, because he's guilty of insurance fraud and everything. So I was thinking he had to actually show up in court, and when they ask, how do you, whatever he say, I plead the Fifth. You know, want to incriminate himself because he's guilty, but he didn't even show up. He didn't want to see Tim, honey. All right. His Fifth Amendment's right and had them waived. All right. For those reasons, the court should grant Mr. Norman a new trial. The trial court erred in denying motions to compel the testimony of Chris Carroll at trial. Oh, Tim wanted to he wanted to look his people in the eye. Mr. Norman moved to compel the testimony of Chris Carroll. Mr. Norman incorporates by reference, as though fully set forth herein, the arguments and case law that he provided in support of that motion, as well as the arguments made regarding those issues as reflected in the transcripts from the hearings held to address those issues, including the voir dire conducted of Carroll outside the presence of the jury during trial. However, in sum, and to refresh this court's recollection, Mr. Carroll refused to testify, relying upon his alleged Fifth Amendment rights. Carroll's testimony was crucial in light of the fact that it is undisputed that he would have directly rebutted Hill's claim that he met with Carroll, and that Carroll discussed with Hill the alleged plot to K. Andre Montgomery. Carroll clearly waived his Fifth Amendment rights based upon the extensive pre-trial audio and video recorded statements that he provided to the government after knowingly and intentionally waiving his rights waiving his right to remain silent and to have the presence and advice of counsel. Moreover, the voir dire at trial of Carroll revealed that he was not in jeopardy, and thus had on basis to assert his Fifth Amendment rights. I guess they mean had no basis. Despite all the foregoing, this court denied Mr. Norman's motion to compel Chris Carroll's testimony. That too was without basis and error. And for those reasons, this court should grant Mr. Norman a new trial. H. My. How many alphabets we gonna go through? The court erred in refusing to instruct the jury in accordance with defendant's proposed jury instructions and consistent with defendant's objections to the government's proposed jury instructions. They got a lot of reasons as to why he should have a new trial, boy. I tell you the truth. Hold on, let me give me a little water. Hold on, y'all. Hold on, let me just take a 60-second break. What y'all saying over here? Please don't forget to smash the like button. Please smash the like button. I heard the bride was beautiful and green. Oh, somebody got married. Okay. They need to take his pen and paper away from him so he can sit down and do his time. Okay. The defendant's proffered jury instructions to this court. Defendant also made oral arguments in support. Defendant also made oral arguments in support of the giving of those instructions. How long we been on air? Let me see here. I hadn't planned on being on. Well, we've been on here an hour. We may have to do a part 2 to this because there's a whole nother document I need to read, guys. And I'm not through with this one. Defendant also made oral arguments in support of the giving of those instructions as well as in opposition to the government's proposed instructions. I'm probably going to come back tonight and finish this one. And then we'll do the Detroit. We'll start on the Detroit story tomorrow. Detroit by way, Arizona court case by way of Detroit tomorrow. But anyway, defendant incorporates by reference as though fully set forth herein defendant's tendered instructions. All of the oral arguments made in support of the giving of his proffered instructions as set forth in the pretrial and trial transcripts, and all of the oral arguments made in oppositions to the government's proffered instructions as set forth in the pretrial and trial transcripts. And I'm reading all of this because I really want to understand what they're basing his request for a new trial on. And I pay for this. As previously fully argued, this court erred as a matter of law in instructing the jury over defendant's objections and contrary to the instructions submitted on behalf of defendant. On that basis, this court should grant Mr. Norman a new trial. Okay, the trial court erred with respect to the jury note and in denying defendant's motions for mistrial based upon the same. Mr. Norman incorporates by reference as though fully set forth herein the oral arguments and this counsel that his counsel made to this court as reflected in the trial transcripts that defendant's counsel does not possess. With respect to defendant's position as to what should have been proper response by this court to the jury's question, as well as defendant's subsequent written submission in support of that position. In short, as previously fully argued, this court erred in so instructing the jury and by denying defendant's motion for mistrial based upon that clear error. So they're saying that the trial court erred with respect to the jury note and in denying defendant's motion for mistrial based upon that. For all those reasons, this court should grant Mr. Norman a new trial. They say that at the end of each reason. Okay, here's J. The trial court erred in denying defendant's motion for mistrial made during the trial of this matter. Wait a minute. The trial court erred in denying defendant's motion for mistrial made during the trial of this matter. Okay, they asked for a mistrial and the court didn't give it to them, so they're saying that that's another reason. During the course of the trial, defendant's counsel made a number of oral motions for mistrial. Defendant and his counsel do not yet have the transcripts containing those oral motions. Accordingly, defendant incorporates, as though fully set forth herein, all the arguments reflected in those transcripts supporting those motions for mistrial. In sum, and as reflected in those transcripts, this court repeatedly erred by denying defendant the right to present a defense, including but not limited to by way of barring the introduction of statements found by this court to be hearsay or irrelevant, where the statements were clearly relevant and or not offered for the court of the matters asserted. Those repeated errors by this court also included barring defendant from introducing clearly probative and relevant information regarding, among other things, the relationship between Andre Montgomery and defendant Norman, and the reasons why Andre Montgomery left St. Louis and traveled around for a period of 6 to 7 months, the reasons why Andre Montgomery's actions resulted in him getting removed from his residence down the hall from defendant Norman, the financial circumstances of defendant Norman, and the insurance application meeting involving Yogman, Andre Montgomery, and defendant Norman. Wait a minute. And the insurance application meeting involving Yogman, Andre Montgomery, and defendant Norman. I don't care what kind of meeting they had, you still didn't have the right to have his life taken, okay? Carry on. The court further erred as reflected in those transcripts by repeatedly allowing the government to introduce over defendant counsel's objections, evidence, including but not limited to statements. And if they did meet, Tim lied to Dre and told him it was about something else, okay? Please, y'all. I know y'all don't believe that. People will lie. People will lie. And Tim is lying. By repeatedly allowing the government to introduce over defense counsel's objections, evidence, including but not limited to statements that inter alia, did I say that right, was without foundation, but was not relevant, that constituted inadmissible hearsay. And the inadmissible hearsay, you know what hearsay is? Stuff you can't prove, stuff you just repeating that somebody told you. That's hearsay. And you better be able to prove it. And the probative value of which was substantially outweighed by the danger of unfair prejudice to Mr. Norman, because Mr. Norman and his counsel do not have the benefit of those trial transcripts. It is impossible to delineate those objections, the arguments made by the defendant's counsel in response, and this court's individual rulings. These errors by this court included the government being allowed to introduce over defendant counsel's objections evidence regarding the fact that at one time defendant Norman owed a debt and had a judgment entered against him with regard to an American Express bill. For all those reasons, this court should grant Mr. Norman a new trial. Hold up. It says, these errors by this court included the government being allowed to introduce over defendant's counsel objections, evidence to the fact that defendant Norman owed a debt and had a judgment. So they saying that American Express debt should not have come in. For all those reasons, this court should grant Mr. Norman a new trial. Oh, we got to move on to K. We're on page 12 and there's 16 pages. So we almost through. We're going to finish this document and I'll come back and read the other document that was filed regarding this later. Okay. After the game. Defendant sought, okay, K, this court erred in barring defendant's expert witness. They're saying that the expert witness should have been barred. Defendant sought to call an expert witness Russell Luce at trial. Tim did. Luce would have provided the following testimony: that family members of individuals routinely purchase life insurance policies as owners of the policies on behalf of other family members, including such familiar relationships as nephews. that family members purchasing such life. Okay. And you see that 2 down there. Let's read this. The court error in allowing this American Express evidence was crucial, whereas here the court repeatedly barred defendant from introducing financial evidence of a favorable nature to himself, yet allowed the government to improperly and baselessly suggest to the jury by way of the American Express evidence that Mr. Norman somehow had a financial motive to have Andre Montgomery murked. So that was back regarding the American Express stuff. B, that family members purchasing such life insurance policies commonly designate themselves as the beneficiaries of those life insurance policies and make the premium payments. Not for $450,000. I'm sorry. Such policies are commonly issued where the owner of the policy has an insurable interest in the individual for whom the policy is purchased. Such insurable interest can include, among other things, the possibility that the owner and beneficiary of the policy will be required or potentially required to answer for the debts of the individual for whom the policy is being purchased, or whether owner and beneficiary will be investigating in or with that individual, or where the owner and beneficiary will be engaging in a business venture with that individual. None of this have anything to do with why you would set someone up to have your nephew's life taken. This is just BS. Despite the fact that Luce's testimony was directly relevant to rebut the government's contentions that defendant Norman's purchase or attempted purchase of the insurance policies at issue in this case was somehow unusual, out of the ordinary, or reflective of a motive to K. Andre Montgomery, this court still barred Luce from testifying. That ruling substantially prejudiced Mr. Norman. Luce would have provided directly relevant context and rebuttal to those arguments by the government. Luce's testimony was also particularly relevant. Hold on, y'all. I'm gonna take me a take something for this. And they gave me some nasal spray too. 1 second, guys. Let me take a 60-minute break. The ruling substantially prejudiced Mr. Norman. Luce would have provided directly relevant context and rebuttal to those arguments by the government. Luce's testimony was also particularly relevant and necessary in light of the government's reliance on numerous insurance company witnesses who knew next to nothing about Mr. Norman's involvement in the insurance application submitted on behalf of Mr. Montgomery. But yet who were allowed to testify that the applications were out of the ordinary and fraudulent. Well, they were fraudulent. Andre didn't ever go to that hospital, Jewish hospital, and get a physical. Andre wasn't making no $50,000, $60,000. Andre's father wasn't still living. It was fraudulent. Okay. Moreover, the court's ruling with respect to Luce was inexplicable in light of the court's allowance of the government's expert witness to testify at trial, even though he was not properly and very belatedly disclosed. In light of the weight and volume of the insurance industry evidence presented by the government, the barring of Luce's testimony was particularly prejudicial to Mr. Norman and undeniably impacted the jury's verdict. As a direct result, Mr. Norman was denied due process and the court's ruling was contrary to Rule 16. Whew, for all those reasons, this court should grant Mr. Norman a new trial. Y'all, we on page 14 of 16. Okay, L. Defendant renews its numerous evidentiary objections and his responses to the government's objections, which cannot be delineated by way of this motion based upon the lack of the transcripts. Defendant incorporates as though fully set forth herein. Again, y'all, all of these alphabetical statements I'm reading here are reasons that the attorney is outlining Tim should be granted a new trial. Hold on. Okay. Where is it? Okay. Defendant incorporates as though fully set forth herein all of its evidentiary trial objections in response to the government's objections. It is impossible for defendant to delineate those objections and responses without the full benefit of the trial transcripts. However, those repeated errors by this court also included barring defendant from introducing clearly probative and relevant information regarding, among other things, the relationship between Andre Montgomery and defendant Norman, and the reasons why Andre Montgomery had to leave Texas to return to St. Louis and live with Mr. Norman. The reasons why Mr. Montgomery later left St. Louis and traveled around for a period of 6 to 7 months. The reasons why Mr. Montgomery's actions resulted in him getting removed from the residence down the hall from defendant Norman. The financial circumstances of defendant Norman and the insurance application meeting. Seemed like, didn't we read this already? I guess I had to repeat this again. Involving Yogman and Andre Montgomery and defendant Norman. That was L. For all those reasons, this court should grant Mr. Norman a new trial. M. Hold on. Defendant should be granted a new trial where, as here, the government improperly referred to and relied upon evidence not of record during closing argument that was allegedly based upon prohibited statements made by Yogman to the government prior to trial. Really? I don't care about any of this. You still set Andre up to have his life taken. This is all irrelevant. Okay, as referenced above, this court denied defendant's attempt to compel Yogman to testify at trial. It is undisputed that the government knew well prior to trial that Yogman's testimony would reveal a central flaw in its case. The government knew, based upon Yogman's pre-trial audio tape statements obtained from him where he had the full assistance of counsel, that there had in fact been an insurance application meeting that was attended by Andre Montgomery, Mr. Norman, and Yogman. Okay, let's say that, hold on. Let's say there was a meeting. He was still set up to have his life taken. There was still a murder that occurred. Let's say he was tricked to a meeting about for this insurance policy and lied to, because there's no way Dre would let Tim take out a $450,000 policy on him. And I have firsthand knowledge. Okay. All right. The government knew, based upon Yogman's pre-trial audio tape statements obtained from him, that there had, where he had full assistance of counsel, that there had in fact been an insurance application meeting that was attended by Andre Montgomery, Mr. Norman. So why did Tim have to pretend to be Dre on the phone? At that meeting, Andre Montgomery signed documents presented and prepared by Yogman. That is why the government tactically chose not to call Yogman as a witness at trial, and it may explain why Yogman disappeared for purposes of service of process during the trial. Yet, during closing arguments, the government falsely and baselessly claimed that at the meeting, Andre Montgomery was forced to sign documents that were shoved in his face or words to that effect. This was entirely prejudicial to Mr. Norman. I bet he didn't know what he was signing. Here, the government was able to have it both ways. On the one hand, avoiding entirely based upon Yogman's assertion of his Fifth Amendment rights, Yogman testifying at trial in a manner inconsistent with its attempts to paint Andre Montgomery's signing of the initial insurance application as either not happening at all or as an unknowing or forced occurrence. And on the other hand, arguing in closing argument that the initial insurance application that was in fact actually signed by Andre Montgomery was done under circumstances that made it involuntary and unknowing. Because the question of whether Andre Montgomery signed the insurance application was a crucial issue. There can be no doubt the government's misrepresentation during closing argument regarding the circumstances underlying the signing of that document resulted in substantial prejudice to Mr. Norman and were part and parcel of the jury's guilty verdict. So why was there so many lies on the applications about Dre? Y'all remember that? We're going to go back over that application. I'm going to go back over the document that shows all the lies that were told on that freaking insurance application, all the jobs they created for Dre, all of the salaries they created for Dre. Okay? Wherefore, defendant James Timothy Norman, by and through his undersigned attorneys, respectfully requests the entry of an order vacating the jury verdict and granting him a new trial and for such other and further relief as is appropriate. Respectfully submitted, Michael J. Leonard. Oh, you did your job on that one. You put together a bunch of shiggity, Mike. You did. He put together a bunch of shiggity. Whew. Okay, I read the 16 pages of the reasons why they're requesting a new trial. And we're going to come back tonight. Hold on. I have one more document that I'm going to read if they haven't posted anymore, but I'll do that later on, guys. I am all read out. Thank you guys for hanging in there with me. The 200 of you that stayed in, I appreciate it. Thank you, Books, for the $10. Thank you so much for the $10 super chat. Happy holidays, PP. I'm praying you get well. Yes, thank you so much.
Thank you.
Yes, I hope I get 100% as well. Great live, PP. As you, thank you, boss man. I appreciate it. Thank you so much for that super sticker. Y'all know I don't come out here begging, but all donations are greatly appreciated. And shout out to everyone who chooses not to put money into the GoFundMe, but you cash at me directly. Okay, because we don't need people in our business. Okay. So the GoFundMe is moving. You're just doing it a different way. All right, guys. Thank y'all so much. I will be back to read the other document. I wanted to at least just show y'all what it looked like. Hold on. Wait a minute. It's this one. It's only, you know what? I don't know. It's 3 pages. Okay, it's not that long. I'm gonna go ahead and do it because I may not come back at all tonight. All right, this here was also filed December the 14th. Defendant Norman's renewed Rule 29 motion. Defendant James Norman bound through his attorneys. Okay, we know all of that. Mr. Norman moved pursuant to Rule 29 at the close of the government's case and at the close of all of the evidence for a judgment of acquittal. Mr. Norman incorporates by reference as though fully set forth herein the oral arguments that defendant counsels made in support of those motions as set forth in the trial transcripts, which have yet to be fully completed. Mr. Norman further incorporates by reference as though fully set forth herein the written submission what defendant counsels filed with the court as a supplemental to its oral Rule 29 motion. Accordingly, Mr. Norman renews his Rule 29 motion. Defendant James Timothy Norman bound through his undersigned attorney respectfully requests the entry of an order entering a judgment of acquittal in his favor, vacating the jury verdict and for such other and further relief as is appropriate. Submitted by Mike Leonard. Wherefore, defendant James Timothy Norman, bound through his undersigned attorneys, respectfully requests the entry of an order entering a judgment of acquittal in his favor, vacating the verdicts and for such other and further relief as is appropriate. So they're saying just toss those verdicts out and just say he's not guilty. Now, I don't know where they do that at, but I don't think that's going to be, I don't even think they're going to do that in St. Louis. All right, y'all. Okay, we're going to get out of here. So that's all the documents, unless they've dropped some more. I'm caught up on those documents. I do have another case that I want to talk to you guys about by way of, it's Detroit by way of Arizona. So we'll be getting into that. Okay. Thank you so much, Candy. I'm glad you enjoyed it. Ciao, boo. Hello, isn't she lovely? How you doing? Shalom, how are you doing? Teletubby hips need to be sent to North Korea. Ooh. This is just ridiculous. Yeah, y'all see it there. It says that he wants a judgment of acquittal entered in his favor. Okay? I'm going to leave it. I'm going to leave that right there. I'm going to leave that right there. Y'all just look at that. Again, thank you again. Let me see. Let me find the, where is the, I'm trying to find the, I wanted to end the poll, but I got to find it first. Oh my goodness. Is this it right here? Yeah, here you go. Right here. Let me find the poll. Okay. 56% of y'all say hell no, thus for. Okay, I ended the poll. There you go. Once again, thank you to everyone who donated to this live. I appreciate it. I'll see y'all later. Your girl, I'm still on the mend, but we getting a little better. Thank y'all so much. Y'all have a rest of the good Sunday. Talk to you later. Tim, you still had Andre's life taken, okay? When it's all said and done. I didn't know, I don't know why that lawyer giving Tim hope. All hope is gone. Yeah, he doing his job, though. Yeah, he is doing his job. Okay, y'all, I see y'all later. Have a good one. Go Cowboys.